Hello, everyone. I'm Bob Levy. I chair the board at the Cato Institute, a libertarian think tank headquartered in Washington, D.C. Today, December the 23rd, 2021, I'm going to discuss the issue of abortion, with particular attention to the pending Supreme Court case in Mississippi and the even more controversial bill in Texas. For starters, I'd like to outline my view on the legal merits of the Supreme Court's decision in Roe v. Wade. Please note, however, that these views are mine personally. They don't necessarily represent the views of other experts at the Cato Institute. To understand the abortion issue, we have to consider two separate questions. First, whose rights trump, the rights of the mother or the fetus? But second, who gets to decide the first question? I have an opinion about the first question. I think the standard established under Roe v. Wade is reasonable in light of the uncertain rights involved. But that's a policy judgment, not a constitutional mandate. No doubt some of you prefer a different policy. So today, I'm going to talk mostly about the second question, who gets to decide? And that is a constitutional question. Many Americans believe, wrongly, that if Roe were overturned, abortion would be banned across the nation. The truth is quite different. Without Roe, the rules governing abortions would be up to state legislatures and state courts. A large number of the states, perhaps most, would opt for an abortion regime, not unlike the federal rules that currently exist. Those rules, modified in 1992, by Planned Parenthood versus Casey, are that states can regulate pre-viability abortions, but only if the restrictions do not impose an undue burden on the mother. Post-viability, abortions can be restricted or even prohibited unless necessary to preserve the woman's health. Most experts estimate that the fetus is viable after about 24 weeks. The validity of that two-part standard depends on when human life begins, which determines, in turn, whether abortion is murder. That scientific, philosophic quandary is a classic example of a policy determination that ought to be left to state legislatures. Ironically, Justice Blackmun, who wrote the majority opinion in Roe, seemed to agree. He wrote, quote, "We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any conclusions, the judiciary at this point in the development of man's knowledge is not in a position to speculate as to the answer," close quote. Having made that powerful point, he then proceeded to do precisely what he said the court should not do. He decided that life begins after the first trimester. Now, Blackmun's inconsistency was not unique. Conservatives and liberals are both inconsistent on so-called social issues, and that's especially evident when contrasting their positions on Roe v. Wade with the arguments they put forward in the sad case of Terri Schiavo, the young lady who died in 2005 in Florida, more than 15 years after she suffered brain damage that left her in a persistent vegetative state. While the battle was unfolding between Schiavo's parents and her husband, President Bush and the Congress intervened to enact a special bill directing the federal courts to resolve the dispute. So conservatives, who are usually strong proponents of states' rights and who vigorously argue that abortion rules should be decided state by state, hypocritically pushed for federal preemption of state decisions in the Schiavo affair. And liberals, who express outrage when the state sovereignty arguments are advanced by pro-lifers in the abortion battles, the liberals invoked identical state sovereignty arguments to support Ms. Schiavo's right to die. The Schiavo case, when does life end, is the flip side of Roe v. Wade, when does life begin? Neither decision, in my view, is the province of the federal judiciary. Judges have no special moral authority on such matters. The rules governing abortion and right to die are best left to the political process to be decided by voters through their state legislatures. That's why Roe v. Wade, from a legal perspective, is a flawed decision. By assuming a legislative role and intruding on state prerogatives, the Supreme Court violated two vital tenets of our constitutional structure: separation of powers between the legislative and judicial branches, and federalism, a system of divided state and federal authority. Still, separation of powers and federalism are means, not ends, and the end result of Roe is a legal regime that many advocates of individual liberty, myself included, find to be a permissible compromise. Essentially, the outcome in Roe and Casey, that is, different rules for pre-viability and post-viability abortions, approximates what I might have voted for if I were a state legislator. Now, that surely does not qualify Roe as good legal scholarship, but it does suggest that one can accept the Roe-Casey rules and still think that Roe was incorrectly decided. The court got the rules roughly right, even though, in my view, it got the legal reasoning wrong. By the way, libertarians reject the notion that abortion and privacy rights are based on the same underlying principles. Think about two cases, often characterized as privacy cases. The first, the abortion case, Roe v. Wade. Second, Lawrence v. Texas, in which the court held that homosexuals can engage in consensual sex in their own homes. It serves no useful purpose, in my opinion, to lump Roe and Lawrence as privacy cases, as if the outcome in one case necessarily dictates the outcome in the other. The question in Roe was the right to abort, which could mean murder if life begins at conception, or it could mean the mother's freedom to control her own body if life doesn't begin until birth. The issue in Lawrence was quite different: the freedom to engage in consensual acts without injury to anyone other than the participants, if indeed to them. The Supreme Court had no grounds on which to resolve Roe because there was no objective basis by which 9 justices could determine whether abortion is a deprivation of the right to life. If the fetus is human, then abortion is clearly a violation of its rights. On the other hand, the court had valid grounds on which to resolve Lawrence, which did not concern the violation of anyone's rights. A ban on consensual sodomy within a home, no less than a ban on watching TV within a home, is a deprivation of liberty under the Constitution. Finally, if, as I argue, the Supreme Court should not be setting the rules for abortion, who should be? Isn't abortion a medical issue best resolved by the mother and her doctor? My answer, no. When it's possible that someone's rights are being violated, either the mother's right to control her own body or the fetus's right to life, we can't leave such matters in the hands of mothers or doctors who may be party to the dispute. Abortion should be decided by voters acting through their state legislatures. Suppose a mother and her doctor decided to kill a sickly infant because the mother's mental health would improve. Suppose a son decided to kill his elderly mother with the doctor's help because the son might be relieved of emotional stress. Those actions are crimes, but only because the political process, that is legislation, has declared them to be crimes. Defining the rights of fetuses, infants, the elderly, etc., cannot be left to individual doctors and their patients. Doctors, no less than the rest of us, occasionally do bad things. Through our legislatures, we declare what actions are impermissible. And when we consign those decisions to the legislative process, we are almost always better advised to vest power in the state legislature, not the US Congress. That way, persons who are aggrieved can redress their grievances by residing in a state whose laws they find to be more congenial. In summary, I agree as a policy matter with the viability standard embraced by Roe and Casey. That's the mainstream liberal position. As a constitutional matter, however, the legal framework should have been established by state legislatures, not by the US Congress or the US Supreme Court. That's the mainstream conservative position. Instead, the court is now dealing with two controversial and divisive cases, one in Mississippi, another in Texas. The rallying cry by liberal pro-choice advocates in both cases is my body, my choice. Paradoxically, that is the same rallying cry adopted by conservatives in the anti-vaccine movement, my body, my choice. Hypocrisy abounds on both sides. In Texas, Governor Abbott and the Texas legislature enacted SB 8, the Texas Heartbeat Act. It bans all abortions after 6 weeks, supposedly when a heartbeat can be detected. There are no exceptions for rape or incest. Most importantly, the state is barred from enforcing the law. Instead, the law can only be enforced by private parties who get a $10,000 reward for each successful lawsuit. That clever tactic was intended to prevent what's called pre-enforcement challenges. If the state were authorized to enforce the law, then doctors, hospitals, abortion providers, and mothers seeking an abortion would surely be able to have the law invalidated even before enforcement, because the law violates Roe and Casey, and its mere existence discourages persons from obtaining an abortion. But if only private parties can enforce the law, then there is no identified party to sue until SB 8 is actually enforced. Plaintiffs cannot, after all, sue every private party who might at some point bring an enforcement action. The effect has been profound, a virtual bar to abortions in Texas, and an obvious deterrent to less affluent women who now have to travel out of state to get an abortion. The law covers any person who causes or facilitates the death of the child in the womb at any time, including providers of transportation or money, and even persons who instruct women on self-abortions, although that provision likely runs afoul of First Amendment protections for free speech. Once SB 8 is enforced, it can obviously be challenged. In fact, there are a number of post-enforcement challenges pending, including a September 2021 case filed by a disbarred Arkansas lawyer against a San Antonio physician who performed an abortion despite the Texas law. It takes quite a while, however, for cases like that to wind their way through the courts. In the meantime, SB 8 is having a chilling effect on abortions that would otherwise be legal under Roe and Casey. The threshold question, therefore, is how to stop the law before it's enforced, and that boils down to a matter of standing. Who has the right to sue whom and when? My personal view is that mere enactment of the law, even prior to its enforcement, is causing injury to persons who either desire or provide abortions. Accordingly, because injury is the prerequisite to legal standing, I would argue that legal action against the state should be allowed. Otherwise, similar legislation authorizing private lawsuits patterned on the Texas statute could be used to circumvent other constitutionally guaranteed rights. For example, the right to gun ownership or to religious exercise. Yes, it's true, there are numerous so-called Keaton laws approving payment to bounty hunters, But the Texas law is even worse. Bounty hunters assist the state in carrying out its legitimate functions. The Texas Heartbeat Act permits private parties to do what government may not itself do. Regrettably, the Supreme Court simply kicked the can down the road in two opinions, both issued on December 10th, 2021. The first was U.S. v. Texas, which addressed the single question of pre-enforcement standing. The Justice Department argued that SB 8 barred federal agencies from performing certain abortion-related duties to implement Roe, such as making abortions available to federal inmates and some members of the military. Furthermore, said the Justice Department, SB 8 subverts the mechanisms that Congress designed for plaintiffs to block unconstitutional laws before they're enforced. Neither argument gained much traction in the court. In an unsigned opinion, the Supreme Court said it should never have agreed to hear the case in the first place. Instead, the case went back to the Fifth Circuit Court of Appeals to flesh out the standing dispute. And as a result, the Texas Heartbeat Act remains enforceable for now. In the second pre-enforcement case, Whole Women's Health versus Jackson, the plaintiffs understood that they could not sue either the state or the Texas Attorney General, neither of whom have enforcement authority. But perhaps they could sue state officials who would be performing administrative functions related to any lawsuits that are filed by private parties. That strategy had mixed success in the Supreme Court. Justice Gorsuch held 5-4 over a dissent by Roberts and the three liberal justices that the state court clerks who docket disputes and the judges who resolve disputes can't be sued because they haven't yet caused injury to anyone. Ditto private parties who might file suit, but who submitted sworn declarations that they had no plans to file suit. But Gorsuch did allow the plaintiffs some right of action in a portion of his opinion, joined by all the justices except Thomas. He ruled that a pre-enforcement suit could proceed only against state officials whose job is to revoke the licenses of doctors, nurses, pharmacies, and clinics if they violate SB 8. That's one option available to plaintiffs in Texas. The only other options are a pre-enforcement challenge, not in federal court, but in state court, or a post-enforcement lawsuit when someone is actually prosecuted. That brings us to the Mississippi case, Dobbs versus Jackson Women's Health Organization, now pending before the Supremes. The law in Mississippi would ban almost all abortions after 15 weeks of pregnancy, with narrow exceptions for medical emergencies or a severe fetal abnormality. In 2018, the Republican legislature passed the law, but a legal challenge stopped the law from going into effect. At oral argument, Chief Justice Roberts was the leading voice on the right for a narrow decision. He tried to circumvent the key holding of Casey, which was plainly based on the viability standard, roughly 24 weeks into the pregnancy. Instead, Roberts argued, the issue before us today is 15 weeks. In other words, he suggested that 15 weeks for the mother to make a decision is not an undue burden. Mothers might disagree, however, given the amount of planning involved as well as personal, family, and financial hardship. In any event, Roberts was apparently pushing to uphold the Mississippi law under an undue burden standard, ignoring the viability standard, so that the court would not have to overrule Roe or Casey. The other conservative justices didn't seem interested in Roberts' middle ground. Alito made that clear. He said the only real options we have are to reaffirm Roe or to overrule it. Now, assuming that Alito, Thomas, and Gorsuch are prepared to overrule Roe, Roberts would need support from the three liberals, plus either Barrett or Kavanaugh. But neither of them said much to sign on to Roberts' compromise. My view, the Mississippi law cannot be sustained under Roe and Casey, and at least 5 justices think those 2 cases were wrongly decided. That probably means the only lifeline for Roe and Casey is the doctrine of stare decisis, respect for past precedent. And personally, that's the outcome I prefer. Otherwise, we can count on further polarization, disrespect for the court as we become more immersed in the culture wars. About a dozen Republican states already have trigger laws that would make abortion unlawful almost immediately if Roe is overturned. Conversely, 15 states and DC have local laws to protect abortion rights, mostly by reprising Casey's viability standard. That's my story, and I'm sticking to it. Thank you very much for your attention.